Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar titled Common Law Risk Management Strategies. My name is Hannah Staunton. I'm a lawyer at WorkCover Queensland and I will be your host for today's webinar. Before we get started, I'd like to acknowledge and pay respect to Queensland Elders past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. Today's webinar will run for approximately 1 hour with some time for questions at the end. If you need to leave a bit earlier, this session will be recorded and we will send a link to the recording out via email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. If time permits, we will try to answer the questions after the main presentation. I'd like to introduce our guest speakers for today's webinar from Hughes & Lewis Legal. Our first guest speaker is Jason Lewis, a Director of Hughes & Lewis Legal. Jason has been working in the compensation field, predominantly workers' compensation and CTP claims, since 1998 in both private practice and various in-house roles. In 2018, Jason founded Hughes & Lewis Legal with co-director Belinda Hughes, who was previously presented in WorkCover's webinar series. And our second guest speaker today is Cara Thompson, an experienced consultant with Hughes & Lewis Legal. Cara specialises in insurance law, in particular personal injury law, and has experience having worked as both a plaintiff and defendant solicitor over many years. Cara is also the current Vice President of the Queensland Law Society. A warm welcome to you both, Jason and Cara. I would just like to remind our listeners that any advice given or questions answered today by either WorkCover Queensland and/or Hughes & Lewis Legal is general information only and should not be taken as legal advice. I will now hand you over to Jason and Cara to continue with today's webinar.
Thank you, Hannah, and thank you everyone for coming along today virtually. We appreciate everyone taking the time to have this conversation. We thought it would be useful to have a talk about some practical tips and practical guidelines which may, we hope, help you, things that you can adopt in your own businesses to manage the risks of common law claims appropriately. I suppose the first thing to say with all of this, though, is remember that ultimately common law claims come about because of an injury. So the steps that we're going to talk about today are about avoiding injuries first and foremost, and the rest should follow after that. As part of our the discussion, we want to take you through initially a very brief introduction to the difference between statutory claims, no-fault claims, and common law damages claims, just to appreciate why they're treated differently. In our experience, common law claims are the ones that are usually the most emotive for all parties involved, and there's some good reasons for that, which we'll come to very soon. We want to talk about the test for how common law claims are determined, how they're decided by the courts, and we want to go through the 5 top factors that we consider to be the vital key points for managing your common law risks. These we see as being setting a system of work in the first place. Secondly, provision of tools and equipment, appropriate tools and equipment. Third, training in the system of work that you've devised. Very importantly, next one, enforcing the system of work. I should just pause to say that in our experience, that's probably where most employers come undone. Most people set up pretty good plans, but as they say, no plan survives contact with reality, and it's the enforcing that's the difficult part for most people. And lastly, but certainly not leastly, you've done everything and something has still gone wrong. What do you do after the injury? What are steps you can take to mitigate your risk after the event? It's not too late. There are things you can do to help at that point. When we take you through these factors, the factors that the courts look at and that you should probably be looking at as well, we'll talk to some case examples to highlight how those have played out in the past, what's gone right, what's gone wrong, and how they can, and hopefully that by telling those cautionary tales, we can give you some examples of how that will help you in the future yourselves.
So to start with, we'll go through statutory claims versus common law claims and why they're different. For a statutory claim to be advanced, a worker need only establish at the outset that there was an event, that is anything that results in an injury to the worker, an injury, that is, an injury which arose out of or in the course of employment where that employment was a significant contributing factor to the occurrence of the injury. If those two factors, being event and injury, are established, a statutory workers' compensation claim is generally one for acceptance. There's no need to go on and consider the circumstances of the injury and whether it occurred due to the fault of an employer. That is, it is a no-fault scheme like Jason just spoke about, and the legislation is beneficial legislation designed to protect workers who have sustained injuries at work and provide benefits where it's appropriate to do so. To understand why common law claims are different and why we're talking about how to mitigate the risk of common law claims being advanced against your business, it is important to understand that these claims are not like statutory workers' compensation claims. Instead, to succeed, a worker must be able to establish that the employer was negligent and that the negligence led to or caused the injury for which the claim is made. In Queensland, there is what we call a non-delegable duty of care owed to a worker by an employer. And that's also referred to in the Work Health and Safety Act 2011, in particular Section 19. But the test for whether or not a duty has been breached is set out in Section 305, capital B, subsection 1 of the workers' compensation legislation. And we've put that up on the slide. It says a person does not breach a duty to take precautions against a risk of injury to a worker unless the risk was foreseeable, that is, it is a risk of which the person knew or reasonably to have known, and the risk was not insignificant, and in the circumstances, a reasonable person in the position of the person would have taken the precautions. So as you can see, a worker to succeed in a common law claim must demonstrate the risk which eventuated and resulted in his or her injury was a foreseeable one, that it was not an insignificant risk, and that there were reasonable precautions that could have been taken by an employer to avoid or mitigate the risk eventuating. To put those issues into context, we note that in respect to foreseeability, it's not particularly an onerous threshold for a worker to meet. Work Health and Safety and Safe Work Australia have published a number of papers, articles, alerts and codes of practice for a wide variety of industries which identify risks for those industries, and more broadly, and where the circumstance is covered, it's generally considered that the risk will be foreseeable, even if you as an employer have not personally read the document. Likewise, if there are similar incidents which have occurred in the past, whether it results in an injury or a near miss, that will also be taken to be foreseeable. The common example is where there's a requirement for a worker to lift, push or pull something in the course of their work duties. That's readily accepted to pose a foreseeable risk of injury associated with manual handling tasks. On the issue of whether a risk is not an insignificant one, this requires consideration of the magnitude of the risk of injury. So, for example, is the risk one that a person might be caught in a moving part of a machine which causes a laceration or worse? Is the risk one that might attract a risk of musculoskeletal injury? Again, it's not a particularly onerous test for a worker to prove. On the issue of reasonable precautions, as Jason said, this is where we see the most cases gaining traction because it generally relates to an enforcement issue, and that's what our focus is on today. That is, are there reasonable precautions an employer might be able to take to mitigate their common law risks, which might go far enough to establish the duty of care has been discharged, or at least establish some significant liability risk to a worker proceeding with a claim. Now, the courts accept the duty of care on the part of an employer is to not only provide a safe system of work, it is to establish, it's an obligation to establish, maintain and enforce a system of work. Section 305, subsection 2 of the legislation goes on to set out what factors a court might have regard to as a minimum in determining whether an employer has taken those reasonable precautions against a risk of injury. And it includes the probability the injury would occur if care were not taken. As an example, that might include examining the system of work in a warehouse to determine how often a worker might be required to manually lift or move boxes of stock, as the more often that happens, the higher the probability an injury might occur. The likely seriousness of the injury, as an example, this might include the possibility of a significant laceration if a mesh glove were not worn when slicing meat. The burden of taking precautions, this generally includes a consideration of the cost of the proposed measure in conjunction with the size of the employer's business. Whilst the workers' compensation legislation refers to reasonable precautions, the Work Health and Safety Act 2011 refers to actions as being reasonably practicable. And its Section 18 provides a useful list of relevant factors, which includes the likelihood of the hazard or risk occurring, the degree of harm which might result, whether the employer knew or reasonably to have known of the hazard or risk of ways to minimise it, the availability and suitability of ways to eliminate or minimise the risk, and after assessing the extent of the risk and available ways to eliminate or minimise it, the cost of doing so and whether that cost is grossly disproportionate to the risk. So you can see there's a number of overlapping themes in both pieces of legislation which consideration must be given to when determining ways an employer can look to discharge its duty of care.
Okay, so ultimately you'll see that as an employer, your duty, you can't realistically absolutely prevent all injuries occurring in the workplace. The question is always going to be, did you do all that you possibly could or you reasonably could under the circumstances? And both pieces of legislation talk about that in a roundabout sort of way, but ultimately that's the guts of it. Did you do everything that you reasonably could do to give the worker the best possible chance of not being injured? There's a classic statement from the case of McLean and Tedman from 1984. The employer's obligation is not merely to provide a safe system of work, it is an obligation to establish, maintain and enforce such a system. So basically it's an ongoing obligation. Every day, top of mind needs to be the consideration that the system that we've devised, was it safe then, is it safe now, has anything changed, is it as good as it can be, within reason. We talked about the 5 factors that come into play when answering that question. The first one is initially setting the system of work in the first place. That's obviously the first step and the most critical one. By that, what is setting a system of work? Well, it's really nothing more than looking at what you as a business are trying to achieve, what tasks are required to do that, and how those tasks can be performed safely and with reasonable efficiency. With any business that you've got, no matter whether you're practicing law or sort of doing plumbing or transporting goods, you'll be bound by all sorts of legislative constraints. You'll be bound by all sorts of practical constraints. But one law, I suppose, that you should always bear in mind, no matter what industry you're in, is Murphy's Law. Whatever can go wrong will go wrong. And when the time comes, and it will, the question will be asked, did you do everything you possibly could to guard against that possibility? And going through these questions here will hopefully sort of cover that for us. The one thing that you've always got to be aware of is that it's not enough to set a system of work that works for you, that makes sense to you. It's not enough to expect that all your workers automatically or intuitively know and understand what you require of them in order to do their duties and to do them safely. The duties need to be explained and a system of work devised and clarified. This is particularly important, and this is something that I've sort of experienced a number of cases over the years, where the workforce is varied. You need to account for a range of ages, experience, culture, and languages. We live in a country of immigrants, and not everyone is familiar with English. Some people can manage perfectly well to do their job, but when it comes to the nuances of safety, you want to be awfully careful that they do, in fact, understand what you've said rather than just being agreeable. What might be known, what might be obvious to one worker cannot be assumed to be so to the next person. And they may not have the same experience in life, they may not have the same experience in the duties that you're asking of them. And that is something that can apply, then that's something that can apply regardless of whether the worker is, as you would say, an experienced worker or not. And we'll come to some cases that deal with that very shortly. One thing that we're often asked about, though, is, well, where does common sense come into all of this? You're asking us to explain to workers every aspect of their job, how to do the simplest things safely. The answer to that is that common sense is not the test for these things. Common sense is, as they say, not all that common, and common sense means different things to different people. The court needs something that's going to work for everyone. To what extent can employers get away with developing a system for the more common, basic, mundane types of work, or where a worker comes to from another business having done the same sort of work previously? You might employ a person because they're experienced in a particular type of work. You might pay them at a level which is commensurate with the experience that they've got, but you can't necessarily assume anything all the same. There's no defence of common law in these cases. it remains incumbent upon you as the employer to provide and devise the system of work, even when the incoming worker has previously performed the task and apparently is very experienced in that. There's a case we'll deal with later that shows a very extreme example of this. But what it comes down to is that you have to recognise that even if the person has done what appears to be the same job somewhere else, there are always going to be those little nuances between businesses, between employers, between workshops, different pressures, different requirements, different ways of doing things that may not seem major at the time, but may make a major difference when it comes to a safety issue. The other thing that, of course, comes into these things is you might have somebody who's vastly experienced in a particular type of work, but then has had some sort of break, a career break, an illness break, whatever it may be. Things may have changed. The training that someone might get in one particular job may become quickly outdated. Is not updated in their previous employer, and by the time they get to you, their knowledge is actually years out of date. To set this system of work that accounts for all of this sounds like a mammoth undertaking, but it doesn't need to be War and Peace. To set a system of work doesn't necessarily require a large document outlining every single step in a process and what action a worker needs to take in every single scenario. In fact, it's better if it doesn't, because something that is too detailed, the devil is going to be lost in the detail, and it's probably not going to be sort of appropriately understood in any event. You do need to prioritise these things, and when it comes to priority, obviously give the priority to safety. It could include, what you could be doing perhaps is including developing a standard operating procedure for some of the more complex tasks, or probably prioritising the more dangerous ones, or where it's determined that there's the heightened risk of injury or propensity for workers to require some additional concentration or process out of the ordinary. And I say that because one of the things that we invariably find is that when a worker's doing their ordinary day-to-day job, everything's fine. It's the one day that they're assigned to something slightly different that things go wrong. They're out of their comfort zone, they're perhaps not entirely confident and not entirely sure, and that's when the problems emerge. It might involve developing a safe work method statement. It could even be a signage displays around the workplace to reveal what is required at individual workstations or with individual pieces of machinery as a constant alert to workers in that area. With signage, probably another thing I'd suggest too is that keep it fresh. There is a tendency for sort of signage up on walls and things, especially if they're tucked away and other things are put over the top of them and they're covered in dirt. They become wallpaper. No one takes any notice of them after a while. There is a system of refreshing is useful. There's no hard and fast rule with this about what a system of work might look like, because there can't be. There's so many different tasks out there and so many different things that can go wrong. It's going to have to be for the individual. What we do here, though, and sometimes it's best to look at what not to do, is to try and work out what you should do. What we regularly hear from workers and their legal teams in these negotiations that we have in common law damages claims is that ultimately the employer's failure has been to fail to assess what the risks might have been and fail to develop a system of work which the workers know and understand, which would have obviated or mitigated the occurrence of the risk which did eventuate. Now, that's just a fancy way of saying they didn't really think it through to say, well, look, here's what could have gone wrong and here's what we could have done about it. And that's ultimately where these claims win or lose. The question always comes down to, should you have seen this coming and what should you have done about it? The How to Manage Work Health and Safety Risk Codes of Practice 2021 sets out when a risk assessment should be done. And the risk assessment obviously is the flow-on point from developing a system of work and talks about the sort of circumstances where you might want to use it. First and foremost, where there's uncertainty about where hazard may result in an injury. If it's uncertain, assume the worst. The work activities involve a number of hazards and there is a lack of understanding how the hazards will interact with each other. I suppose the classic example for me with this is on a construction site where you've got a number of trades working together. Each trade doing their thing individually might be perfectly safe, but it's the sort of the coordination or lack of coordination between each where the dangers can emerge, and often do. Changes at the workplace occurring which could impact on the effectiveness of control measures. Now, things do change over time. You refine your ways of doing things, sometimes for better, sometimes for worse. The graphic example of changes occurring in the workplace, of course, is when machines or pieces of equipment are altered, sometimes for the sake of efficiency, but sometimes at the cost of safety. That's why it's never a set and forget situation. You set the system in the first place, but it always needs to be updated and checked and monitored. An example of how developing and revising a system of work can impact on a common law claims, this is an example that we've come up with, which a bit of a funny one that you wouldn't necessarily think of. It's a case of Fennel and Hill jewellers. Now, the employer, Michael Hill, obviously a jewellery store, the court found that they did not have an adequate system of work in place to verify the identity of prospective purchasers. So basically what would happen is they'd have a customer come in, they'd ask to have a look at a piece of jewellery because they're deciding whether or not to buy it. The system that Michael Hill had, and they did have a system, it was that if the item of jewellery was worth more than 20 grand, then the policy was that the retail assistant had to request ID from the purchaser, naturally, so that if they decided to run off with it, you had some record of who they were. On this particular day, what happened though, the item being examined had a ticket price of around $13,000, so under the limit. Now, $13,000 is still a lot of money, but it was under the limit, so the worker wasn't required to ask for ID, and she didn't ask for ID, and the person, the customer slash thief, took the item of jewellery and then immediately tried to leg it. There was a sort of a little bit of a scuffle, and at the end of it, the worker developed a psychiatric injury as a result of this interaction, as you'd expect. Now, after this happened, the system was reviewed and a new system implemented, which required workers to obtain ID from prospective purchasers for any purchase over $2,000 rather than $20,000. Now, in hindsight, that's a much better idea because an item worth $2,000 is probably just as attractive to a thief as an item worth $20,000. The court agreed with that because the court was not satisfied that the first system they had in place, the $20,000 limit, adequately turned its mind to preparing a system which adequately guarded against the risk of injury. It was, and the other thing, this is another key thing, was in comparison to the cost involved in implementing a $2,000 system as opposed to a $20,000 system, well, the cost differential is next to nothing. It was a simple thing they could have done. It would have guarded against far more risk than the previous system did, and it would have in fact prevented this particular risk. And it was a reasonable, simple measure that they could have done and therefore should have done. Oh, sorry. In relation to developing a system of work, the other question that comes up a lot is who should do it? Now, we're all in particular industries and all have particular skill sets that are unique to those industries. None of us are good at everything, and not all of us can have ability to sort of to look at every aspect of what we do from a safety perspective. We look at it from a business perspective, or we look at it from a cost perspective, and we look at it from an expertise perspective. But are we skilled in the safety side of things? Well, most of us probably not. The query that's often asked by some of the sort of more savvy claimants lawyers is, you as an employer didn't have personal expertise in safety issues, so you got someone who did. So you say, now who was this person? This business supervisor, health and safety officer, whoever it might be. The issue to consider though is whether it's appropriate for that person that you've chosen, you've given that responsibility to. Is that a responsibility? And usually the answer will be yes. That requires some sort of heightened knowledge, specialisation, or recognised expertise. Now, for example, devising a system of work to operate a crane on a construction site requires input from engineers to ensure the crane is located correctly with no risk of toppling over. System involves the installation of electricity to a building, would necessitate the input of a qualified electrician. These sorts of things which you as the business owner or HR manager may not necessarily personally have. Now, this can come back to bite you badly if you choose the wrong person or lumber someone with a responsibility that they're not really up for. The case of Curl and BM Alliance coal operations was an interesting matter from a number of years ago. There was significant criticism from the court on the employer in this case. Now, what happened here was this was a case involving a mine worker who was working back-to-back 12-hour shifts because that was the system that was in place, and that's a whole other story. The drive home was about a 400-kilometre drive. The inevitable happened, fell asleep at the wheel and had very serious injury. The issues related to what policies and procedures the employer, the mine operator, and all the other parties involved had in place to manage fatigue, driver fatigue. Now, the employer, his actual employer, employed a business development manager who was charged with attending the mine site and assessing workplace health and safety for workers. So you've got a business development manager who was also sort of doubling as the WHS manager. She was put in a bit of an awkward position because during the trial, she was cross-examined. She made it pretty clear that she considered herself to know enough about workplace health and safety and perhaps even a bit of an expert. Unfortunately, it didn't sort of come out that way to the court. They asked her a number of searching questions on cross-examination, as tends to happen. She was asked whether she'd ever worked as an actual coal miner, and she said no. She was asked if she had workplace health and safety qualifications, and she answered no. So she didn't have the piece of paper. On further questioning about how she could have expertise, she came up with the immortal line, which I do feel a little bit sorry for, because I probably would have said the same thing, but it's not going to sound good. And what she said was, I knew a lot about mining. I knew what a shovel looks like. I knew what an excavator looked like. I know what a dump truck looks like. I know what they can carry. I know what coal is. So I believe, like I've been on lots of mine sites, I believe that I could, in my judgment, be able to look at a document and know if it's crap or not. Now, that's probably all true, but the court didn't think that was enough. The court came back with with all due respect, which is usually a precursor to giving someone a complete roasting, which unfortunately is what happened here. Familiarity with the appearance of shovels, excavators, dump trucks and coal is not a sound basis to claim expertise. She completed generic and side inductions, but she was not shown to have any expertise that would fit her for the role of a safety officer. Her answer strongly suggests that she had no appreciation of the intricacies involved. Now, we raise this one because it's not uncommon for a lot of employers to put extra responsibilities on existing employers. I remember one job that I had where I was appointed as the privacy officer for the company. Now, my expertise is obviously in workers' compensation. I know nothing about privacy. And if anything had gone wrong there, I would have had a great deal of difficulty in sort of justifying my so-called expertise in that area. So be very careful before delegating responsibility to someone to make sure that it is in fact fair to do so, and fair on them. You can see it's very important with developing the systems to ensure that those who are responsible for devising the system have the appropriate skills and knowledge to do so. That will usually, they can't just have those skills and knowledge, they have to be able to prove that they have them. And usually that will involve some sort of paper qualification, or at least very extensive, very specific and appropriate experience in the field. It may be sometimes the case a certificate qualification, extensive experience, other qualifications that ensure the person responsible has some intimate knowledge of what tasks are to be performed and how to safely perform them in a way which complies with relevant health and safety requirements. Now, there's three parts to that, and they're all equally important. They've got to have the qualifications are good because they're provable. Extensive industry experience is also good, in some ways better, but it's sometimes a little bit harder to prove. They must have intimate knowledge of what exact tasks are to be performed and how to safely perform them. So again, it's not just a case of they know what needs to be done, they need to know how it's to be done safely. And they also need to be able to sort of talk competently about how it complies with relevant health and safety requirements, because those are the sorts of arbiters which the court is going to use in measuring how well it's been done. With the next point that comes up quite a bit, especially almost all the time for labour hire employers and for a lot of other employers, is that the system of work needs to be advised not just for your own premises, it needs to apply everywhere that you send your workers to. This has obviously become a much bigger issue lately with COVID and flexible work arrangements, people working from home and so forth, but it's always been an issue. There are a lot of jobs which by their very nature, labour hire, the obvious one, but construction, transport, disability care, all of these are jobs where you're going to spend the vast majority of your working life not at the employer's premises, but somewhere else. Now, the problem with that, of course, is that you as the employer don't always have control over the location where they're sent. You can send them there, but what happens after they get there is sometimes out of your hands. It could be, as I said, a construction site, somewhere where a delivery is being sent, a mine site like the Curl one we just talked about. In those instances, what can you do and what should you do? Well, the answer to that is you do as much as you possibly can, because treat it as much as possible or as near as practicable to the situation where if the person was still with you. So if you, for example, say, well, look, they're out of sight, they're out of mind, they're not my problem, that's not going to be enough. A totally hands-off approach could see you wear a substantial apportionment with respect to liability. And this is even the case when it's the third party, the owner of the premises or whoever that has, in fact, perhaps most directly caused the injury. Your share of the liability with them will increase inversely proportional to how much you do. So if you do nothing, you're probably going to wear a big chunk of the liability, even though the accident was, strictly speaking, someone else's fault. And the reason for that is simple. It's because you as the employer, the buck stops with you. You can't just sort of send your workers off into harm's way and forget all about them. You need to take some precautions to make sure that you're sending them to a safe place. The more hands-on you can be seen to be in examining and satisfying yourself that whoever the third party is, that other premises are, that they've got appropriate policies and procedures of their own in place, similar to what you might expect to have in your own, then the more chance you have of reducing or perhaps even completely eliminating your liability. Very rare, I should mention, that you completely eliminate your liability, because ultimately you are the employer and ultimately the buck stops with you. But again, it comes down to a big case of, well, how much of the liability comes your way and how much goes the other way. Of course, the other main reason you do this is so that the more you check out the other workplace, the more precautions you take, the more you would hope there is the chance that there'll be no injury in the first place. So therefore, of course, no claim. But if there is, those are the considerations the court will look at. Practically, this might look at making inquiries with the host employer or other third party about what their safe operating procedures are, their safe work method statements. Have a look at those, keep them on file to prove that you've had a look at them and satisfied yourself of them. Their procedures, site visits, so you can actually go and make sure that the procedures are in fact being complied with. And again, recording that you've done so. You haven't just sort of taken people's word for it. You've gone and checked for yourself, and you've satisfied your responsibility as the employer to make sure that your employee has gone to a safe place. You should be doing all of this, obviously, prior to sending the workers to site, if at all possible, so that they're not just left to a situation where they're going into an unknown and having to make the best of a bad situation, a potentially bad situation.
All right, so we might turn to our top 5 factors, number 2, which is the provision of tools and equipment. Now, there's no doubt that an employer must provide adequate tools and equipment to workers in the performance of their work duties, and that those tools or pieces of equipment must be adequately maintained and obviously in safe operating order. There are several factors which are relevant in relation to the provision of tools and equipment, which includes inspections to ensure they're fit and proper for purpose, a maintenance program, for example, the servicing of forklifts or other equipment, installation of safety features, even where they may not be standard, such as guarding, where there might be some moving parts, and of course, exercising caution with modifications. There may be a reason why it was the way it was in the first place. The Managing the Risks of Plant in the Workplace Code of Practice 2021 is online. That's designed to guide employers on how to manage plant in the workplace, including how to inspect and maintain it. It requires periodic inspections, specific tests, repairs, isolation procedures, and it's something that you should be familiar with if you do have plant and equipment in the workplace that your workers are required to be in or around or using. Now, whilst it's an ageing case, it is relevant to this particular issue, and it's an interesting one. There's a matter called Tetu and James Vane Proprietary Limited. Now, it is a 1999 decision, so it is ageing, but we think it highlights the requirements in relation to this particular topic. It's an example of the relevance of systems for ensuring that equipment is provided and that it's appropriate and that it has been maintained. The plaintiff in that case was an aerial artist, so a trapeze artist, performing at the then Jupiter's Hotel, which most of you will probably remember. The performance was moved to make it more aesthetically pleasing for the audience. As part of that change, there was a decision to shift from lifting the plaintiff manually to a trapeze to using a mechanised winch. The winch was not provided by the employer, but had been a spare that was held by Jupiter's, presumably in a room somewhere. There were additional structural changes also made to the set, and some leftover cable from some other works were used to connect the winch to the trapeze the plaintiff was to use. So not new cable, it was leftover cable. Prior to the aerial show starting, the plaintiff had noticed an unusual noise and some rubber was installed to stop that noise, so there was some maintenance performed. Now the show opened and it was running 8 times a week. After 100 shows, the cable, which was the leftover cable, started to fray, and a non-qualified rigger replaced it with some more cable that again had been left over as well. During the 113th show, the plaintiff fell when it broke and she was significantly injured as a result. Workplace Health and Safety investigated and found that the plate and winch was damaged, and it was worn with a propensity for the winch to bend and distort when it was left on for too long. It was also quite relevantly found not to comply with Australian safety standards. It was noted also that there was no qualified rigger that had been involved in devising the system of work, maintenance of the equipment, or any inspection process as part of the installation and use of the equipment. The court noted that any suitable or suitably qualified rigger would have readily identified the safety issues without hesitation. It was also found that the lack of compliance with the Australian safety standards and deficiencies in identifying problems with the equipment gave rise to liability. Indeed, the modification of the equipment in the manner it was, without input from an appropriately qualified rigger, was considered to be grossly negligent, and that it showed a reckless disregard for the safety of the plaintiff, given the magnitude of the risk of accident and injury. More recently, in a case of People and the Smith Snack Food Company, the court found an employer did not provide safe plant and equipment. Now, in that case, the plaintiff was crushed by a robotic arm of a machine, which she'd been clearing at the time due to cardboard becoming jammed within the confines of the machine. The plaintiff had entered the machine by a sliding door. The manufacturer had reportedly designed the machine so it would stop operating when the sliding door would open. However, in this particular instance, it didn't. It was argued that this was a latent defect and not as a result of any breach of duty by the employer. However, there was evidence that some years earlier, a similar incident had occurred, but in that case without injury being sustained. After the previous incident, the employer had relied on information from the manufacturer that corrective measures were implemented without any additional system of inspection or testing being implemented by the employer to verify this. The court considered the previous incident ought to have put the employer on notice that further careful monitoring and attention was required, and that there ought to have been an increased system of inspection and maintenance. It was not sufficient to simply rely on the manufacturer's advice in that case. Further, it is not generally enough for an employer to implement a set and forget procedure for providing tools, plant and equipment which are fit for purpose. This was highlighted in a decision of RSL Care and Wallace. There, a plaintiff was assisting a patient in a shower when she slipped and fell, sustaining injury in 2008. The shower surface was installed in 2002. At the time of the installation, the floor complied with the relevant Australian standards for slip resistance. But between 2002 and 2008, there was no maintenance of the floor, which complied with the manufacturer's guidelines. The floor deteriorated and the employer was found liable for the occurrence of that particular injury. Now, that decision highlights the need for the routine maintenance and inspection, which is required over time.
All right, so you've set your system of work, you've designed it as best you can, you've provided appropriate tools and equipment. The next thing obviously is the training of the personnel involved. Now, as you might have guessed, this is one of the most important factors and certainly one of our top 5. Training extends not just to instruction as part of the induction process. Induction processes, in my experience, over the years have sort of been hit and miss. Some are spectacular, some are terrible, but all of them happen very much at the start of your employment. And if you're in the job for a long time, a lot can change in that, and they never cover everything. They just can't. So therefore, the training needs to include regular instruction, monitoring and enforcement throughout the life of your employment. Importantly, it also requires a verification of understanding as part of the process. Now, I guess I use the analogy here. It's a little bit like issuing someone with a driver's license when they're 17 and saying to them, look, do you know the road rules and do you know how to control a car? Yes, okay, here you go for your life. That's not how it works. There you have to sit through numerous tests and so forth before they'll let you loose on the roads. And the same thing really does apply in the workplace too. You need, before you give someone dangerous equipment to operate, or in fact, any potential to injure themselves at all, you need to be absolutely confident that they understand what's at stake. Now, in many of the cases we see, the workers that are arguing that whilst they might have been trained, it was not understood, and no one really did check to see if it was understood. And that could be due to a number of factors, due to lack of education, learning disability, language barriers, whatever it might be. There are so many things that can get in the way of what you might give the instructions clearly. Whether someone understands them clearly is entirely a different matter. In a matter of REC and Queensland Rail, again, a relatively old matter, 2005, His Honour Justice Freiberg, as he was at the time, noted that in relation to the issue of training of workers, gave a useful little soundbite, and that was training to perform an action involves more than issuing warnings and giving commands. It requires the employer to demonstrate and explain the actions, and then to have the employee practice it until it becomes automatic. That is one way of reducing the risk of injuries due to inadvertence. the finding that on the balance of probabilities, had the appellant performed its duty to the accident would not have occurred was justified. So basically the problem there was that, yes, they'd been trained initially, trained as in told, but had they been shown, had they been demonstrated, had their understanding been tested, perhaps not so much. It was in a similar vein, it was noted in the case of Brisbane Youth Services and Bevan, 2018 case, so relatively recent. Generally speaking, the greater the degree of danger inherent in the work, the more likely will be the need for instruction and warning. Well, that makes sense. The employer's duty to exercise reasonable care for the safety of his employees will often require that skilled employees be reminded periodically about the risks of their work and the need to guard against them. That's extremely important. We all know that the more we do things, the more mundane and routine they become, the more we become complacent and the more we let our guard down. As lawyers, we have a professional indemnity insurer who gives training sessions, and one of the things that they ram home to us every time they do this training session is that the most basic mistakes are made by the most experienced of workers. And it's one of those simple truths. When you do make a mistake, no matter how experienced you are, it's always the silly little things. And that's why those things, even the basics, need to be the subject of constant reminders. And reminders, not about every aspect of the work, because some of them won't have consequences, but physical risks obviously do. Following on from these concepts, we know that the factors relevant to training and instruction include, firstly, you've got to take the workforce into account. In the case of Bahane and Woolworths 2017 case, interesting one because she sustained a shoulder injury as a result of picking duties. Now, the reason this happened was because she had a constitutional shoulder problem, which became symptomatic as a result of the work practices. Picking is very repetitive work, it's very fast work, and you do tend to get a lot of injuries as a result of it. Now, the court noted, or the medical evidence was, that this problem that this particular worker had was common in 10 to 15% of the population. So we're not talking something that was, some microscopic percentage. It was 10 to 15%, a reasonable number. And accordingly, the court considered that this risk was foreseeable, or should have been foreseeable, to the employer, and needed to be taken into account when devising and instructing the plaintiff in the system of work. So in other words, you've got a situation where the duties that you're giving the person to do might be perfectly safe for 85 to 90% of workers, but they're not safe for 10 to 15%. So you need to take that into account when setting those duties. Of course, that means that you need to know about the pre-existing conditions as well, but that's a whole other story. It's something that you do need to take into account. One size does definitely not fit all. Another thing you need to take into account is obviously the experience of the worker. Now, a lot of people have come back to me over the years and said, well, look, this was an experienced worker. They knew the risks. What were they thinking? Why would they have done it this way? The experience of the worker is not a be-all and end-all. Now, the case that really drives this point home is the case of S.J. Sanders and Schmidt. And this was a case involving a truck driver. Now, he was injured stepping down from the cabin of a truck, and he'd been an experienced truck driver, and he'd been performing the work for almost 20 years. So I'll repeat that. He'd been doing it for nearly 20 years, getting in and out of the cabins of truck drivers, and on this one, and on this one occasion, he fell. Now, he fell because it was found he wasn't using 3 points of contact. Now, I would have thought that was a fairly basic thing for a truck driver to know, and the employer said the same thing. They said, well, look, he's a truck driver. He's been doing it for 20 years. How could he not know that? Now, what the court actually found in that case was that the employer could not rely on that 20 years of experience to get them off the hook for giving proper training instruction on how to safely enter and exit the truck cabin. Now, how that came about was the employer basically said, well, look, we didn't train him how to do 3 points of contact. We assumed he knew that, as you would expect from a 20-year plus driver. The problem was that no one could prove that anyone had ever trained him in that ever. And his argument, which the court ultimately accepted, was, yeah, I've been doing this for 20 years, but I've been doing it wrong for 20 years. And no one ever told me otherwise, and I've just been lucky up until now. So again, as I said at the outset, when you employ a worker based on their experience and you pay them based on their experience, you still can't take everything for granted. It's amazing how even the most experienced of people can come across a situation in their workplace that they've never encountered before. Or, as in the case of Schmidt, they've just simply been doing it wrong all this time, and so far it hasn't come back to bite them, but eventually it will. So don't just produce a training video, a document or a video. Make sure that they've got an opportunity to understand it, comprehend it, and prove that they understand it. And that brings us to our next case of Coles and Schmidt. Sorry, beg your pardon, Coles and Harris. This one's an intriguing little one because this is a case involving a safety step, as the picture there. These are these little cheerfully coloured sort of plastic square things that you see in supermarkets and other retail outlets across the country and across the entire globe. There must be millions of them in existence. Everyone knows what they are. You step up onto them to sort of to reach high things. Pretty simple piece of equipment, you would think. This case, however, highlights that things aren't necessarily that simple. Even the simplest of things still needs specific training and instruction. The funny thing, the soundbite from this is always a little take-home message from all of these cases. And in this one, the classic line was, calling something a safety step doesn't make it safe. And that's precisely the problem here. The worker was using the step to arrange stock on a high shelf. When she attempted to dismount down from the step, she fell on the ground and injured herself. Now, she'd been progressively working her way down the aisle with the safety step before this happened. She'd obviously used the safety step many times before. So similar vein to the Schmidt case just before, routine task that she'd done many times before. That was precisely the basis on which Cole said, well, this is not something we have to train her to do. It's a safe piece of equipment. It's the appropriate piece of equipment to use for that task. There had been training in it because we gave an induction book and training video when she first started with us. They then sort of said, well, they tried to have 2 bob each way and then sort of said, well, look, alternatively, it doesn't really matter whether we trained her or not, because even if we did give her heaps of instructions or training, she made a deliberate choice as to how to use the step and ought to have known that doing it the way she did it would cause her a risk of harm. Now, what she did was that with the picture there, you can see there's the front and back of the step and there's the 2 sides. The intended method of operation is to step down straight back on the little step thing. She stepped down to the side and then it all ended in tears because of that. The Court of Appeal noted that the task she was engaged in wasn't a complex one, but the danger arose due to the way the step was used by her. However, the danger arose in a way that wasn't or couldn't have been obvious to her. So it's not something that was so obvious it you could go without saying. Apparently, with these things, stepping backwards is quite safe. Stepping sideways is not. From her point of view, she couldn't see the difference. What difference would it make? Apparently, it makes a lot of difference. The court also said that while the risk of injury was low, there ought to have been additional precautions taken by Coles, including training and supervision, which was noted not to be particularly onerous on them. An organisation the size of Coles shouldn't have had any difficulty sort of doing a little bit of training and supervision. A little bit of training and supervision would have identified that she was stepping off the side of this thing rather than off the back of it, and would have, you would think, instructed her to do otherwise, reminded her to do otherwise, and then this would never have happened. The Harris decision does highlight the lengths an employer needs to go to in order to ensure workers are properly trained and instructed in a system of work, even for the most basic of things. Some businesses are very thorough with training, and most businesses will have some level of induction, but the ones who are sort of perhaps regarding themselves the best are the ones who couple this with observations conducted at various intervals of employment to ensure the training is being followed and understood, periodic quizzes. Now, this is something that I suspect a lot of businesses probably don't do, but it's not a bad idea because it all comes back to that verifying the understanding that we talked about before. And of course, refresher training at yearly intervals or when policies are updated. Definitely when policies are updated, because sometimes changing policies can have unintended consequences as far as safety is concerned. Even if nothing has changed, yearly intervals are also not a bad idea because people forget. People get into bad habits. Using the driver's license analogy again, I'd struggle to get my license again now, I think, because of all the bad habits I've got into over the last 30 years. But refresher training, the idea of that is to prevent those habits getting ingrained. The difficulty, of course, with any of these any training, especially the more onerous you make it, the more regular the training is, the more involved it is. The question always comes, well, look, where does it get to a point where the cost and burden of doing this is just too much for an organisation? That might be all very well for an organisation the size of Coles to do all of this, but if I'm just a small shop that employs 2 people, it's just out of proportion. I can't possibly do it. It's not cost effective for me. There can be a reluctance in our experience for sometimes employers to adopt training regimes which are up to the standards the courts require because for cost reasons and also because they perceive the risk as being low. We've only got a small number of employees. They're all, employees. They're all good people. They're all sensible. They know what they're doing. Or the classic, my employees are all my family members, so there won't be a problem anyway. There can be a tendency for the shield the right mentality to creep in. I'd really caution you against relying too much on these arguments about the cost of training. Courts aren't very receptive to those generally because, and you can sort of see why. When you look at it, if something terrible happens, you've got a seriously injured person who's had a life-changing event, and the best that the employer can come back with is, oh, well, it would have cost too much to guard against that happening. The court's going to need a lot of convincing on that point. They're going to need to know that it would have cost a real lot to be worth the risk that eventually eventuated here. The other thing that they will look at too is, all right, there was an expensive way you could have obviated this risk. Was there something else you could have done? Was there some other alternative? Was there anything at all that you could have done that would have reduced this risk? Sometimes it can be surprisingly little that you can do that will end up being enough, and each case is different. We know from cases like Harris that reviewing the duty of care and work health and safety legislation that there must be something done if employers to protect themselves. And ironically, another Coles decision, a matter of Gray, the following year, in this case, the plaintiff was again working in a distribution centre. He participated in a 2-day induction course, which included instructions about how to safely lift boxes, as you'd expect. About 18 months later, he picked up a 12-kilogram box of water and failed to comply with the training which he'd been provided, became injured. He tried to argue that Coles should have gone further than they did and ought to have adopted additional measures to prevent the risk of injury occurring, such as pallet turning, so boxes could be moved closer to him. In that case, so interestingly enough, it was 18 months from the induction, and I can't see that there was a lot done between times, so that was probably pushing it in terms of the regularity of training. But nevertheless, on this particular case, the court found that it was what he was talking about was doing was an unreasonable burden on the employer, the size of Coles that is, and that they had in fact done enough. So they must have been satisfied that the training that was done 18 months before was pretty good. The court then went on to sort of say that it was satisfied that the quality of training was such that there was nothing further that Coles ought to have done in the circumstances, and significantly, there was no reason why the plaintiff couldn't have just complied with his training and done what he was told. So in that case, perhaps Coles was perhaps a little bit unlucky in the first one and perhaps a little bit lucky in the second one. There's a lot of similarities between the two cases, but different outcomes, and obviously the slight differences between the two were enough in that particular case to change it. Many of you will already be familiar with the various codes of practice which are published in the WorkSafe website. There's basically codes of practice, specific codes of practice for most industries. In addition to the codes, there are numbers of resources available to workers to assist in navigating the training requirements, available to employers to assist in navigating training requirements of workers. These things include induction checklists, training registers, programs. It also provides assistance with respect to organising workplace visits for further guidance and consultation, so you can have people come and explain it to you properly and how it applies to your workplace. With all of these things, though, what I'd always say is whatever steps you take, whatever resources you download, whatever resources you incorporate into your systems, make sure that there is a record of it. Because when the day comes, when you're asked to sort of explain what you did, what precautions you took, it's very important to be able to show, well, look, these are all the steps I did. You're wanting to establish that you did as much as you possibly could do under the circumstances, and something still went wrong regardless of all that. You want to be able to do that for two reasons. One, obviously, to justify to the court why you should not be liable, but secondly, to sort of for the sake of your own conscience, obviously, given that someone's been injured here.
Right, so let's talk about enforcing the system of work, which we think is one of the most important aspects of this particular topic in terms of mitigating risks. And we're talking here about to what extent a system of work is required to be enforced. Does it mean threatening to terminate a worker's employment? What if an employer does all they can, but the worker just disregards the instructions that have been given? Is that sufficient to raise contributory negligence? Can that defeat a claim? Well, contributory negligence is another topic for another day. It is a very broad and complex topic, but it does feed directly into enforcing the system of work. Generally speaking, what we can say is that it's all well and good to have the best systems of work, the best training programs and refresher training, but quite often liability will turn on the issue of enforcement. What we sometimes see is a disconnect between what management or supervisors are requiring and what is actually occurring in the workplace. That is, there is sometimes a disconnect culture where workers are engaging in shortcuts or workarounds that tend to increase the risk of injury to them, and there can be a bit of a culture of bystanders with nobody stepping in to stop that occurring, and that could be for many reasons, including fear of losing their job. A classic example we often talk about is the decision of Tompkins and Kemp Meats. In that case, the plaintiff was a slaughterman in an abattoir. He sustained a laceration injury while undertaking knifing duties without a protective glove on. The issue at trial in that case was whether there were sufficient grounds for contributory negligence to be found, considering that against a background as to whether the system of work as alleged by the employer was actually enforced. The plaintiff there was an experienced meat worker. He'd had several claims for workers' compensation previously relating to lacerations from knife cuts before this particular incident, and the employer submitted that the plaintiff knew of the risks associated with the use of knives, given that he had that history, and that he consciously failed or refused to wear a protective glove, which had been made available to him by the employer. Whilst the case relates primarily to contributory negligence, as I said, it really does feed into how the system of work was enforced, in particular the need to wear PPE in the workplace. The court noted that in relation to the enforcement of the requirement to wear gloves, that the wearing of protective gloves may reduce the incidence of knife cuts, and employees may be aware of that fact, but the wearing of gloves is an incidence of the employer's system of work. The employer has the responsibility and capacity to enforce obedience to the system. The defendant, that is the employer, did not do so until after the incident. Further, the evidence is clear that in the so-called trial of the gloves, only 3 pairs were made available, one in each of 3 sizes, small, medium and large. Yet there were 13 knife workers on the slaughter floor. There were insufficient gloves for all the employees, and the employer did not enforce the wearing of the gloves by the plaintiff or any other employee. So noting the lack of enforcement, it made it impossible for the court to conclude that there was any reasonable basis on which to allow contributory negligence. And it highlights the fact that whilst there may be a system of work requiring something to be done, in this case, the wearing of PPE, it is necessary to ensure that workers know of the need for compliance and importantly have the ready ability to comply. In this case, even if there was a system of wearing PPE, it could not be complied with as there had been insufficient PPE provided. So the key takeaway from that decision is that whilst there is a system of work, if you want to rely on it and have a chance to defeat a claim or at least see a reduction for contributory negligence, there must be an availability for the workers to comply with the system of work and a strict adherence to the system of work on the part of the employer, with no room for shortcuts or workarounds being adopted. A departure from the accepted safe work practices could see liability found in full without a worker having to take any or any significant responsibility for their own conscious decisions leading to an injury. Another example of a lack of enforcement is in the matter of Kelleher and J&A Accessories. In that case, the plaintiff was exiting the cabin of his truck when he sustained a back injury. His job required him to deliver batteries to customers, each weighing around 20 kilograms. The plaintiff was not provided with any manual handling training and had not been trained by his employer on how to get in and out of the truck in an appropriate way. Prior to starting with the employer, he undertook a pre-employment trial, but the truck he used to complete the trial was a larger one than the one he was ultimately allocated to use. During a driving test, he was instructed to exit the truck in reverse, maintaining 3 points of contact, and that was done verbally. However, in the first 3 weeks of work, the plaintiff was working alongside another worker as part of an observation period. During that time, the plaintiff failed to comply with the instruction to exit the truck in reverse. The observer who was working alongside him saw this and failed to correct the plaintiff about what the correct technique ought to have been and require him to comply. The court found that not only should the employer have enforced the correct system of work by the observer or the employer correcting the plaintiff in how to exit the truck, but it ought to have had regard to a Queensland Road Freight Safety Guide, a publication not unique to the employer but industry-based as a means for adopting safe work practices. Likewise, in another meat worker case, in Spina and Australia Meat Holdings, a meat worker was injured when not wearing a mesh glove again. The employer had provided the plaintiff with a mesh glove, other safety equipment and a safety booklet at the time of his induction 8 months prior to injury. His first assignment, though, was in a division of the employer's business which did not require the plaintiff to undertake any knife work, and he was there for around 7 months. He was then transferred to what's called the gut box, where he was required to use a knife. At the time of the transfer, he was not given any further instruction about the knives or any reminder about the need to wear a glove. The court found at first instance, which was upheld on appeal, the real cause of the plaintiff's accident was, however, that there was no insistence that the mesh glove be worn in the gut box area. On the defendant's case, the plaintiff was given advice and a booklet at the time of his induction. He carried his mesh glove to the workstation each day, but it wore it intermittently. From the time of the plaintiff's induction to the date of the accident, no person in authority had directed him that at all times he should wear the mesh glove. I think the instructions given were completely inadequate and insufficiently specific for an inexperienced knife hand, and that there was no enforcement of wearing the mesh glove.
All right. Well, another thing that comes up, of course, is that in a perfect world, no one would be injured in the first place and we wouldn't be having this conversation. What a lot of employers do ask is, though, okay, an injury does happen. Not everyone who's injured brings a workers' compensation claim, and not everyone who's injured certainly brings a damages claim. Is there anything that I can do to sort of reduce the chance of an injury turning into a damages claim? Bearing in mind that you have some, 80,000 people per year bring statutory claims, only about 3,000 bring damages claims. There are, in our experience, there are no guarantees, of course, but there are certain things that can be done which will improve the odds for that happening. A damages claim, I think, Cara and I have both acted on both sides of the fence over the years, and have acted for injured people against work cover and have more recently acted for work cover. And I think we can safely say that a damages claim is an end resort for everyone concerned. It is better if it can be avoided, and there are certain ways that work cover actively tries to do it. And I think, surprisingly, those can actually be quite effective if given a chance. One of the things that work cover is very focused on is early intervention, positive return to work outcomes. In the years that I spent working for injured people, when people were sort of weighing up whether or not to bother bringing a claim and go through the ordeal of legal action, one of the questions that I would always ask them is, well, how much has this injury really changed your life? Is it the case that you've been through a terrible ordeal, but it's largely behind you and hopefully you can get back to life the way it was and it's not going to have long-term consequences? If that's the case, then why would you do this? If, on the other hand, you've got a situation where, despite everyone's best intentions, life is never going to be the same for you again and you're going to have all sorts of trouble working, well, then you probably, unfortunately, have to do it. And that's precisely why work cover is so committed to and tries to get employers on board with return to work. Anecdotally, a successful return to work is not only a positive for a worker and their injury outcome, but a positive for employers and minimises potential common law exposure. For precisely the reason that I just said, there's if someone's back at work, safely back at work, and appears that they will be fine from here on, and absent any particular bad blood against the employer, there's no real incentive for them to do this. If they do go ahead and do it, if they do bring the damages claim will almost always be for a smaller amount. So obviously the dollar impact on the employer is going to be smaller as well. Everything comes down to what's the long-term impact of the injury, and specifically what's the long-term employment impact of the injury. However, as an employer, it can be difficult, and I can understand well how it can be difficult for employers to navigate situations where the worker is injured, especially in circumstances where there's apparent, potential or alleged negligence attached to them. What do you do in that situation? What do you do in the situation if you handle it badly? Do you cause a common law claim to be brought that might not have otherwise been brought? Does the physical injury manifest into a secondary psychiatric and mental injury claim? There is so much potential for you to make the situation worse. But there is also a lot of potential for you to make the situation better. Questions that people often have are, do you address the circumstances of the injury and the possible fault with the worker up front? Do you sort of tackle the elephant in the room? Do you involve them in the investigation process? Do you apologise? And we'll come to that in a bit of detail later. Do you try and retain and redeploy the worker and give them something useful that they can be doing and hope for the best? Or do you terminate them and again hope for the best, that they'll just go away quietly and you'll never hear from them again because there'll be no claim? from experience, I suggest to you that that last option is probably a fairly forlorn hope. These are all questions that we see employers struggling with on a frequent basis, and much of the answer lies, it's a big question, it's a very expensive question, it depends on a lot more than just a potential common law claim. When you ponder these questions, you've got to consider things like, well, obviously other legislative intervention, enterprise bargaining agreements, fair work, individual employment contracts, the impact on your business as a whole, the impact on other workers in the business, morale impacts. All of these things are two-edged swords, and all of them will influence your decision. What we're going to talk about today, though, is just the one little narrow part of that issue, and that's how it affects your common law damages claims. As a general rule, if you're looking at the common law damages claim, a potential common law damages claim, or an actual one in isolation, the best possible outcome for us is that the worker is back at work as soon as possible, doing as substantively as possible their pre-injury duties. And that's actually genuinely, and I can say this from having acted on both sides of the fence, the best outcome for both sides. What we often see is where the worker is retained, redeployed, or involved in the business on a continuing basis, this does seem to mitigate the risk. I'm sure Kara's had the same experience, but I certainly had this for many years while I was acting for injured workers. New inquiries would come in. They tell you their story. It'd be a fairly significant injury. The circumstances of the injury were such that there was clearly a very good case against the employer. And my recommendation would be to them that, well, look, you should bring out a common law damages claim. You kind of have to. But once you got to the point of explaining to them, and perhaps not all lawyers do this, but once you got to the point of explaining, we are going to technically be suing your employer. It is a situation where work cover sort of meets the cost, but there is premium impact, and there's obviously an emotional impact for the employer too. Yeah, are you comfortable with that? It was amazing, and perhaps a little bit encouraging, how many potential inquirers turned around and said, oh, look, in that case, no, I couldn't do that. My employer's been so good to me. They were good to me before this happened. They've been even better to me since it happened. I don't feel right about doing it. Now, obviously, that doesn't happen in every situation. There are some people whose focus is purely and solely on the money, and that's it. But there are a surprising number of people who their decision is genuinely made based on how they feel they've been treated. And sometimes that it's not how they've actually been treated, it's how they perceive they've been treated, but nevertheless, the result's the same. So one thing that another thing that we found, it's just funny, the little things that sort of trigger people, but a perceived lack of empathy or a lack of interest can incite a worker to take a claim. Classic lines for me, they didn't even call an ambulance for me. Probably it wasn't actually required, but nevertheless, the fact that they didn't bother, in inverted commas, to do it triggers people. They never contacted me once when I was on work cover is another one. And in a lot of cases, that's perceived by the injured worker as being indifference or lack of compassion or lack of care. I suspect in the reality is in a lot of cases, it's the employer has probably been a little bit sort of frightened as to what to do and thinking, well, look, should I harass the person when they're on work cover? Am I allowed to? Is it only going to make the situation worse? There's no straight answer to that because every worker is different and every worker will react differently. But so I can't give you an answer that will satisfy 100% of situations, but from my experience, I would say that in the majority of situations, most people will respond relatively positively to some sort of contact interest being shown. And it's a fine line. It's interest and it's compassion, it's not harassment. Sometimes there's absolutely nothing you can do. Sometimes, the claim's driven by factors outside your control. In a lot of cases, we find, and I've again experienced this on both sides of the fence, it's not the person themselves who's the main driver for the claim. They have someone behind them, a spouse, a relative, a parent, a child, a friend, who is who more or less sort of pushing them into it or egging them on. Sometimes that person can hold a great deal of influence over the worker and more influence than you can. And sometimes you'll just have to ride with the situation. The human side of a claim or a potential claim is absolutely a difficult one to manage. The law is easy compared to that, but nevertheless, it's very important to recognise. And coming back to that, there was one of the things that were asked at the outset of this was, what do you say sorry to a person? And that's the big question. And one of the issues that employers often query is, what's this business about apologies in the legislation? Does it do any good? Are there any stats on that? The answer to that is no, there are no stats on that because they would be impossible to gather. You can't get a reliable answer to that question. So all you can work with is anecdotally and instinctively. A lot of people won't want to apologise for the same reason that they won't want to call a worker, or they won't want to visit a worker in hospital, or they won't want to do any of these things because they're too worried that it'll be construed as an admission of liability and admission of guilt. And that's precisely why in 2018 there was a review of the legislation that found that this simple little word can make such a difference that it was thought beneficial to amend the legislation to allow employers to make two things: expressions of regret and straight out apologies. Now, coming back to those, you'll see the purpose of this division is to allow an individual to express regret, and there's a matching provision for apologies, about an incident that may give rise to an action for damages without being concerned that the expression of regret may be construed or used against them. Now, very simple philosophy here. Employers should be allowed to show human compassion without it coming back to bite them. And it can make a big difference. Sometimes it may make no difference, but it certainly can't do any harm. And this provision makes sure that it will do no harm. So I would, it doesn't apply in every case, obviously, because it would be silly, obviously, in cases where, say, the employer and WorkCover are running the argument that, well, look, we don't, it might be potentially a fraud case, or we don't believe the incident happened in the first place, the whole thing's been made up, whatever. It would be hypocritical to issue an apology in those situations. However, there are a large number of situations, and especially in psychiatric or mental injury claims, where it can be entirely appropriate. I've had situations, for example, where bullying claims, where the perpetrator of the bullying has been a well-known bully, unfortunately has been let run slide for too long, has since gone, and the employers in those cases have said, look, we tolerated that person for way too long, they've now gone, we're sorry, we dropped the ball. And I've said, are you happy for me to say that to the worker? And it's never actually come back badly for us, even before this provision came into place. Now, with this provision in place, you can certainly say it without any concerns at all. I use the analogy, it's a little bit like if you get told by someone that there was a death in their family, what do you say? You say, I'm sorry. It doesn't mean you're responsible for the death, it just means you're sorry. So I'd encourage employers to think about this. If any case is borderline, it just might make the difference. There's no stipulation in the legislation as to what the apology or the expression of regret looks like, or how you do it. The only proviso I would put on it is make sure you do it sincerely, or don't do it at all. WorkSafe suggests an apology or expression of regret is likely to have the most impact, however, if it is given as soon as practicable, delivered by the persons directly involved, is genuine and sincere, surprise, surprise, and is accompanied by a direct explanation about what is being done to address the situation. I think that's vitally important, because a lot of people will justify legal action in their own minds on the basis that I don't want this to happen to anyone else, because that's a fairly noble, altruistic sort of justification, and most people can feel comfortable using that to convince themselves that they're doing the right thing. If you can say to them, well, look, it isn't going to happen to anyone else anyway, because we are already taking steps to make sure it doesn't, that removes that impetus. And very simply, it uses words like sorry. Don't prevaricate, don't use sort of weasel words, don't sort of squirm and duck and weave, just say sorry. As I said before, there's no data to confirm whether how much employers are using it and how much difference it's actually making. But as I said before, because of this, it cannot possibly do any harm. All right, that brings our presentation to an end. We hope that you've enjoyed and benefited from it, and you've gained something useful from it, or at the very least, you sort of understand what's involved and what sort of things you need to be aware of when faced with this situation. Hopefully, if you are in this situation in the future too, you'll know what sort of questions to expect from the WorkCover lawyers. You'll know what sort of information that you need to provide them to best help your situation. And ideally, of course, all going well, you'll never actually be speaking to us in the first place, because no injuries will ever happen. Thank you.
Thank you, Jason and Cara. There were some great take-home messages that you shared with us today. And thank you to the people who have taken time to comment and send those comments through to us. So we do appreciate it. To our audience, thank you again for tuning in this morning. We hope you found this session useful. As mentioned earlier today, this session has been recorded, and we will send you out a copy early next week, and also a copy will be uploaded onto our Work Cover Queensland YouTube channel. So thank you again, and please keep an eye out for details of our next webinar, which we will publish soon. Have a great day.